Hey guys, welcome to today's Legal 101. Being a Monday, it's on employment and labor relations law. What we're talking about today is procedural fairness during disciplinary hearings between employer and employee. And we are borrowing from a judgment by Justice Rika that was delivered this year. And I will tell you the facts, but there's going to be a bit of a mention of public officer ethics and procurement law. Now, these are the facts. The claimant, former employee, was employed by KNH in 2007, but he was suspended in November of 2018, about 13 years later, and at this point KNH referred to him as Chief, Corporate Affairs and Communications, but he maintained that he served under two roles. Role number one being that he was Manager, Marketing and Communications, and role number two that he was Head of Corporate Affairs and Communication. And the two offenses he was accused of was number one, bribery, soliciting money, and number two was sexual harassment. It was alleged that he had asked for 283,000 shillings from a company named Blue Media. Now, Blue Media was in the running for provision of services to KNH. KNH wanted a health practitioners directory published on the Kenya Medical Practitioners and Dentist Board magazine. The claimant asked Blue Media to provide the 283,000 so that it would be allowed to be on the panel to provide this work. And allegedly, the claimant was paid 50,000 shillings and asked for sexual favors from one of the representatives of Blue Media. In the meantime, the Treasury had issued a circular, and there was an executive order that was applicable to all public entities that provided that all advertisements outside the government advertising agency had been banned. So for a private entity such as Blue Media to make the advertisements on behalf of KNH, KNH had to seek a waiver of that circular and the executive order. There was no such waiver, okay? So when a local service order was signed by the claimant's deputy, the claimant sought to find out what happened. Why did you sign this when there was no waiver? And his deputy told him, I was pressurized by somebody from Blue Media. So the claimant said, we need to suspend this LSO because KNH is not compliant, and being a public entity, compliance is very key. But his advice was disregarded, and the tender was awarded to Blue Media regardless. It is at this point that he was then accused of soliciting the bribe and sexually harassing one of the employees of Blue Media. There was a disciplinary hearing after the suspension that took place in May of 2019. So he was suspended in November of 2018, and the disciplinary hearing was in May, June of 2019. He said the disciplinary hearing was presided over by what he called a staff disciplinary and advisory committee, and he said that was an illegal committee. We'll talk about it further down. He said the committee lacked the powers to hear the matter because some of the members of the committee actually assisted Blue Media get the tender, so they were not impartial in the matter. So he objected to their membership right before they gave their decision, and he named them about 4 officers: the chair of the committee, who was a deputy director of finance, another person who was a director of supply management, another who was a director of administration, and KNH's corporation secretary, and he said they were all involved in the procurement process. They should have recused themselves, but none of them actually did. During the hearing, he also had a colleague with him who was a trade union representative. That person was not allowed to speak. They were told, kazi yako ni kunyamaza. That was despite the provisions of Section 41 of the Employment Act. The claimant expected that the operating guidelines for the hearing would be the terms and conditions of service revised in 2010 to 2011. But what was actually used during the disciplinary hearing was a human resource manual that was still a work in progress, that was actually approved 4 months after his disciplinary hearing, okay? And he said, had KNH used the terms and conditions of service, they'd have presented him before a competent committee, and I will let you know what that competent committee was. The Staff Disciplinary and Advisory Committee was the collective name for 3 different committees. Committee number 1 was known as Board of Management Staff Disciplinary and Advisory Committee, which dealt with cases of discipline involving directors and management staff. It comprised of 9 members, and it was chaired by a person that the members chose. And some of the members that were supposed to be part of this committee were one member of the hospital's board of directors, one representative of the principal secretary in the Ministry of Health, one representative of the principal secretary in the Ministry of Finance, the principal College of Health Sciences, University of Nairobi, the director KMTC, one representative from the Inspectorate of State Corporations, the hospital's CEO, the hospital's director of clinical services, and the director of human resources. That was committee number 1. Committee number 2 was the hospital management staff disciplinary and advisory committee, which handled disciplinary cases involving professional and general staff. Committee number 3 was the departmental staff disciplinary and advisory committee, which did not specify the employees who would be hired by this committee, but it provided that the committee would be chaired by the heads of department. Now, the letter which invited the claimant to the disciplinary hearing did not specify. It generalized it and called it the Staff Disciplinary and Advisory Committee. Okay? So he put in his response, 18 pages long. But despite his response, despite his complaint on the composition of the committee, despite non-appearance by his 2 accusers, the person who said he sexually harassed her, and the other who said there was a solicitation of bribes, none of them actually appeared for the disciplinary hearing. But he received a termination letter after the hearing. He sought an appeal within the organization through the Human Resource Committee of the board. The appeal was determined a year later. He was not asked to participate, nothing. He only learned of that decision when he went to KNH to collect his half-monthly salary. He had been suspended, so he was receiving half his salary. So the court considered all of the above. And this is what the court said. Number 1, Section 10 of the Employment Act requires the employer to list down the duties and responsibilities of an employee. It has to be very clear. Now, in this case, KNH was not able to clearly provide the job description and the job title. So the court said he had 2 roles. He was Chief Corporate Affairs and Communication, as per the payslip, but he was also Head of Department Communications, as per the letter of dismissal. And now, given his 2 positions, the only committee that could hear him was committee number 1. And you can go back to the video to see what committee number 1 was vis-a-vis the other committees. The court said none of the 9 persons named in the invitation letter was identified as a board member. None was identified as a representative of any of the ministries. None was from any of the other organizations I have just mentioned. And so the court said this committee had no mandate to give a decision pertaining this matter. The court said the committee had no mandate, but also it was made up of conflicted individuals who should have actually been witnesses. Okay? And so they were not impartial and they were not credible. He gave an example. The chair of the committee was the head of security who worked with the human resource on investigations against the claimant. Of course, he would not be impartial. The court said, look at what the corporation secretary said, that what you're telling us about the composition of this board is a sideshow. That is a person who's already not impartial. So the court said, as an administrator, when you're making decisions that require you to follow procedure, you must obey your own regulations. You must create an atmosphere that enables fair and objective hearing. You must not prejudge whoever is appearing before you. Your language must depict self-restraint, and anything short of this compromises a fair hearing. The court also noted that not allowing the claimant to cross-examine, to confront his 2 major accusers was a fundamental procedural misstep that prejudiced the claimant. not giving him an opportunity during appeal as well. Just coming up with a decision a year later was a further violation of his right to fair administrative action. Not having proof of bribery and sexual harassment was a further violation. Not seeking prosecution under the Sexual Offences Act or under the Anti-Corruption and Economic Crimes Act was another violation. And actually, it was something to be looked at strangely. There's so much noise today, I'm so sorry. The court found that there was no valid reason for the dismissal. So the court said, what am I going to do in this case? You have asked for many things. Particularly, you have asked that you be allowed to go back to work. The court said, I cannot allow you to be reinstated, because an order of reinstatement only works if it is given within 3 years of dismissal. It had been longer than that. So the court said, we're going to go the re-engagement way under section 49(3)(b) of the Employment Act, where there's going to be a restoration of the employer-employee relationship with variations that are necessary, but the work that the employee would be given would be comparable to that which he worked immediately prior to termination at the same salary level. The claimant had asked for arrears of salary from the date of suspension to the date of judgment, but the court said these amounts will be charged as against public funds, yet since suspension to present date he had not been working there. So the court just said, give him his withheld salary from the date of suspension to the date of dismissal of his appeal. And in the alternative, the court said he could be compensated for unfair and unlawful termination by being given an amount equivalent to his 12 months gross salary, which was 3.8 million. And he was told to choose either re-engagement or, that's my cat, re-engagement or compensation within 30 days. And 30 days later, KNH would comply with whatever he chose. So today's Legal on One was quite long. It was wordy for me also. But I hope whatever you have picked, for me, the things that are most important is that government entities, public entities should conduct regular governance and compliance audits, because then the auditor, external ones at that, because then the auditor can tell you, these job descriptions that you have are very ambiguous. Okay, can you be very clear about somebody's job title and their work at this organization? Okay, they can be able to tell you, you have made various changes to people's employment contracts. Can you please make sure this is formalized? Okay, and if you have in-house regulations, an external auditor will be able to tell you whether the regulations are in line with the laws that exist, whether it is time to revamp, whether it is time to remove some clauses that have been overtaken by events. So if you have regulations, they will still be looked at, especially when it comes to employment disputes. And lastly, as an employee or agent of a public entity, your allegiance should be to the people of Kenya. Us, we come first. Okay, so if you work at KNH, we come first. Any other public entity, we come first. You cannot betray us because you have individual interests. Like in this case, the majority of the management betrayed the people, betrayed the hospital, because they were protecting whoever won the tender. They subjected this man to court procedure for so long. They now have to choose which one. They now have to comply with whatever I choose. And so it's just a whole lot of a process, a very long process that can be avoided if there's a compliance audit, if people are willing to listen, if people are going to abide by the provisions of the leadership of Chapter 6 on leadership and integrity and the provisions of the Leadership and Integrity Act. So that marks the end of this very long Legal 101. Ask questions if you need to. Listen as many times as you need to, especially if you work in a public entity, especially if you work in procurement. This person is a very good example of integrity at a place that's already very convoluted, or where you're the only person standing with values. So see you tomorrow. Bye.